Welcome to the debate. Our focus today is one of the most complex paradoxes in American constitutional history, the 1908 Supreme Court ruling in Muller v. Oregon. To really get it, we have to remember the constitutional climate at the time. This was the peak of the Lochner era, where the court was just aggressively protecting this idea of freedom of contract.
Right. And just 3 years earlier, in Lochner v. New York, the court struck down a very similar law for mail bakers, creating this huge precedent for the liberty to contract under the 14th Amendment.
Exactly. And that's what makes Muller so fascinating. So the court is facing almost the exact same kind of state labor law, but it reaches the complete opposite conclusion. It upholds the 10-hour work limit, but only because the workers were women. The entire distinction was based on gender.
So the central question we have to grapple with today is this. Did the Supreme Court's decision in Muller v. Oregon represent a crucial progressive victory, one that opened the door for essential worker protections when the courts were so hostile? Or did it, in fact, fundamentally solidify gender discrimination by defining women as this separate, dependent class? I'm going to argue that Muller was a necessary strategic success, a vital legal compromise that expanded the state's ability to protect its most vulnerable workers.
And I'll be arguing that the core judicial reasoning of Muller actually institutionalized sexist concepts of female dependency and reproductive value, causing deep and lasting harm to women's autonomy. The protection it offered, well, it came at the devastating cost of constitutional equality.
Okay, so when we analyze Muller, we really have to place ourselves in the political reality of 1908. I mean, the prevailing doctrine of the time, this economic substantive due process, it basically tied the hands of any state legislature trying to fix the brutal conditions of the Industrial Revolution. The Lochner majority had just said that the state's interest in protecting health was, and I'm quoting here, too shadowy and thin to sustain labor regulation for men.
They were facing a constitutional wall.
A total wall. And so reformers, powerful groups like the National Consumers League led by Florence Kelley, they knew that universal gender-neutral labor laws just wouldn't survive a court challenge. They recognized this legal hostility, and they saw the limit on women's hours as a pragmatic if painful legal maneuver, an opening wedge, they called it, for broader worker protection. And the vehicle for this strategy was the now famous Brandeis Brief. Instead of just relying on legal precedent, Brandeis brings in a brief that's only 2 pages of legal argument and over 100 pages of sociological, medical, and industrial facts. It was revolutionary. And this brief pioneered the use of facts to show a genuine, rational state interest in health and safety. And that successfully circumvented the Lochner precedent. The court's unanimous acceptance of the law was a huge moment. It proved that the state's police power could, in fact, regulate industrial conditions where employees and employers were demonstrably not on equal footing. It cracked the Lochner shell.
Okay, I acknowledge the political astuteness of the strategy. I mean, it was a brilliant deployment of evidence, I'll give you that. But that's really where my praise ends. Because while the strategy was novel, the court's ultimate justification for upholding the law was fundamentally discriminatory and remains, I think, constitutionally corrosive. The opinion is just steeped in the rhetoric of female physical and intellectual inferiority. It made the entire success conditional on accepting inequality.
Well, that language has certainly
always been dependent upon man. He went on to say she is not an equal competitor with her brother and therefore needed a special care from the legislature. This wasn't just some factual observation about physical difference. It was a judicial classification of women into a status that was basically the same as minors.
That rhetoric is, of course, inexcusable by modern standards. But at the time, this was the language of constitutional survival. I see why you focus on that textual damage, but let me offer a different perspective on the actual function of the Brandeis Brief. The brief was the necessary factual scaffolding to meet that really rigorous Lochner test of reasonableness. The evidence it presented, paternalistic as it sounds to us now, it reflected the consensus of medical experts at the time. They argued that long hours were especially detrimental to women's bodies, and they cited physician reports on, general deterioration of health, anemia, pelvic organ congestion. This factual basis gave the court a non-economic reason to intervene, which was a necessary concession to achieve a vital public safety goal.
That's an interesting way to frame it, but I would argue that the success of the brief lay precisely in its willingness to embrace the rhetoric that women were, in effect, disabled by their reproductive organs, and that conveniently justified their political and economic exclusion. The court seized on this physical difference, that the two sexes differ in structures of body, and then just leaped to the legal conclusion that this difference justified stripping them of the fundamental right to contract that men enjoyed. And even worse, the decision explicitly framed women's well-being as an object of public interest and care in order to preserve the strength and vigor of the race.
The phrase vigor of the race it's difficult to defend today, I agree.
It's more than difficult. It is the crux of the problem. It explicitly conflates a woman's individual health with her maternal function and, by extension, the future of the nation. The legal methodology here didn't just use social science. It used social science and often highly questionable science that argued things like, excessive intellectual pursuit would damage a woman's reproductive capacity. It used that to reinforce existing structural sexism. It legitimized treating women as wards of the state, defined primarily by their fertility. Why rely on that rhetoric if the purely sociological facts were enough to meet the Lochner test?
Because the judges themselves were products of that era, and the argument had to be culturally palatable to a conservative court that was determined to defend laissez-faire economics. The goal was to protect women from the greed as well as the passion of man in an era of, 72-hour work weeks. The reformers were playing constitutional poker with the hand they were dealt. And what's more, the Brandeis brief method, relying on concrete facts rather than just abstract legal precedent, it later became instrumental in challenging gender discrimination laws in the 1970s. Cases like Reed v. Reed relied on the same principle, using facts to show a classification was not reasonably related to a state objective. The method itself proved to be a tool for justice.
I'm sorry, I just don't buy that the methodology excuses the outcome here. We can appreciate the procedural innovation of the Brandeis brief without sanitizing the resulting constitutional stain. The focus on protection directly and immediately undermined women's economic autonomy. By limiting women's hours, but not men's, the law gave men a competitive advantage in the workplace, especially in skilled, high-wage jobs.
But in the absence of this law, both sexes would have been forced to work those terrible hours without any recourse at all.
That is true, but the restriction was often interpreted by employers and even by labor unions as a measure to push women out of higher-paid, male-dominated trades. We see this documented clearly. The labor organizer, Ella Sherwin, wrote that this kind of protectionist legislation will drain women out of all highly paid and highly organized trades. The law's whole premise, that women needed protection, it built on the assumption that women relied on men for wages. It normalized the idea that, motherhood was women's primary role and work came second, and that suppressed their ability to achieve financial independence. It was a huge setback.
That's a very compelling argument about the economic consequences. I'll grant you that. But have you considered the alternative? Without Muller, the legal landscape would have remained entirely hostile to any labor regulation. It would have left all industrial workers vulnerable to the absolute worst exploitation. The immediate demonstrable goal was to improve living conditions, improve the health of the entire family and society. And this was consistent with other progressive policies at the time, like the creation of the Children's Bureau, which extended its advocacy to prenatal care. These laws weren't enacted in a vacuum.
But they were seeking social betterment by defining half the population out of constitutional equality. The fact that Muller helped facilitate broader gender-neutral protections, like the ones upheld in Bunting v. Oregon in 1917, which finally limited hours for all factory workers, that just proves that the Muller ruling was a deeply flawed temporary fix. But the toxic rationale that lingered long after the benefit expired, the constitutional definition of women as a class dependent on the state, was now baked into the law.
But you're dismissing the critical procedural step. Muller provided the necessary evidentiary and jurisprudential precedent that the state could intervene for a worker's health. Once that hurdle was cleared, it was only a matter of time before the regulation was applied universally, which is exactly what happened in Bunting.
The problem is that while it served as a stepping stone for general labor law, it left a deeper, far more corrosive precedent for reproductive autonomy and gender equality. That decision's central holding, that women's bodies are an object of public interest under police powers because of their potential role in motherhood, that provided the legal foundation not just for positive maternal health policies, but for later attempts to regulate women's choices about birth control and abortion. It continuously reinforced the argument that a woman's physical choice is inherently a public concern, unlike a man's right to contract.
We're talking about the difference between protective legislation and restrictive legislation. The context matters.
But they became indistinguishable in practice. This paternalistic logic was resurrected decades later in the form of so-called fetal protection policies. Corporations, citing the need to protect the vigor of the race, excluded women of childbearing age from over 100,000 jobs, often higher-paying jobs, unless they could provide documented proof of surgical sterilization. I mean, this is a clear, direct anti-autonomy impact stemming from the Muller reasoning that persists long after the limited labor benefits were surpassed by gender-neutral laws. The message was clear. Your autonomy is secondary to your reproductive potential.
And that connection is deeply troubling. Certainly, the language in the decision clearly invited that kind of state overreach. However, we have to understand Muller in its immediate historical context. It was a strategic legal victory that successfully challenged the rigid Lochner-era definition of liberty to contract. It allowed states to intervene to protect the health of an entire class of workers who were facing immediate crushing exploitation. While the justification was rooted in the, yes, inexcusable gendered assumptions of the time, its procedural success, validating state police power through sociological facts, was absolutely vital for the evolution of constitutional law. It was a forced trade-off, but one that opened the door to modern regulatory frameworks.
I'm not convinced, because the historical necessity doesn't erase the permanent constitutional harm. The cost of that procedural success was the judicial codification of women as inherently dependent, defined primarily by their reproductive capacity. The shadow of Muller, this idea that women's bodies and choices are uniquely subject to state police power, it persists to this day. It illustrates how legal rationales rooted in protectionism can become these entrenched barriers to full equality and autonomy, perpetually treating women as second-class citizens.
Muller v. Oregon remains, then, a profound paradox in American jurisprudence. It illustrates this deep tension between the pursuit of necessary social protection and the struggle for individual equality.
Right. The material truly reveals that the debate over how the state should legislate the physical differences between sexes and what justification it uses continues to inform our most fundamental public policy decisions today.